Hello, welcome everyone to this 10th International Workshop on ADR, which will be conducted on a span of 3 days starting from the 26th to the 28th of August. It's a pleasure to have you all with us today. Mediate GURI is a social initiative led by members across the globe. The aim of the organisation is to bridge the gap between the public and litigation. We are creating a social awareness campaign showcasing mediation as the future. We strive to provide you with the best lecture series through access to the best speakers around the globe so that you can add value to your legal studies and your legal career. I feel honoured today to welcome our esteemed guest, Mr. Markus P. Beham. Markus is an assistant professor at the Chair of Constitutional and Administrative Law, Public International Law, and International Economic Law at the University of Passau, Germany. He is also an adjunct lecturer in international law at the University of Vienna, Austria. He holds a joint doctoral degree from the University of Paris-Nanterre and the University of Vienna, and a doctoral degree in history as well as an LLM degree from Columbia Law School in New York. Prior to returning to academia, Markus was part of the international arbitration group of Freshfields, resident in the firm's Vienna office. He continues to provide expert advice for private clients, NGOs, international organizations, and states on matters of international law, EU law, and arbitral procedure. He has acted in cases before the International Centre for Settlement of Investment Disputes, the International Criminal Court, German Arbitration Institute, and the Austrian Supreme Court. Thank you so much for joining us, everyone. Without further ado, let us begin. I would request that Markus please takes the stage and enlightens us all. Remember that you can all ask your questions in the chat box below.
Hello, and good afternoon, or good evening, or good morning, wherever you may be present today. Thanks again for the invitation to speak here and for the kind words of introduction. I hope everyone can see and hear me clearly. If that shouldn't be the case, then please just give me a quick shout in the chat. If I can just very briefly correct the introduction, although it would have been a pleasure to have, I have not so far acted in front of the International Criminal Court, but before the International Chamber of Commerce arbitral proceedings. That's what the ICC stands for. And that brings me also to what I will be talking about today, of course, which is on the one hand mediation, as is obviously the larger topic of this webinar series and the mission objective also of Mediate Guru. But also about arbitration, and a topic that's of particular interest to myself and hopefully also to you after this lecture today is the question of public interest in arbitral proceedings. I will now start the presentation. And what I would like to talk about today is the topic of public interest in both of these methods of alternative dispute resolution. I will try and take about the next 40 minutes or so, and then hopefully get started with a question and answer session, in which I'm very much looking forward already to your input and hoping to be able to engage with you in your questions. Now, the way by which I want to go through the topic is to start by defining what is public interest, what do we understand by this term, then moving forward to what are the duties of arbitrators and mediators, and then finally a term that I have tried to coin in this respect is the Renaissance arbitrator, and I'll be talking to you a little bit about what I mean by that. Now, starting with the first part of my presentation, which is looking at defining what is public interest. Now, obviously, public interest is something that we are mostly used to dealing with in the world of arbitration when we talk about international investment arbitration. or generally when we're talking about any kind of disputes involving sovereign entities, particularly states, but also, of course, state entities such as state-held corporations, for example. I want to go a little bit further than this general discussion of how we deal with sovereign entities in disputes, how the public interest affects how such disputes should be conducted, and look at how public interest more broadly impacts alternative dispute resolution, particularly arbitration and mediation. Now, when we look at the terminology of public interest, what do we mean? What can we understand by this term? Now, public interest, on the one hand, quite broadly framed and understood, could simply be equated with the public good as such, could be equated with the broader interests of the public or particularly of civil society. But public interest goes beyond that when we use it in a legal setting or also perhaps in a political science context, in that public interest as a standing term represents a maxim of government or of governance. So the idea is that governance is conducted in a way that will benefit the public interest. And this is also what informs the term that particularly one will be familiar with in the common law area, particularly in the United States, is public interest law, meaning representation of matters in the public interest. So not necessarily a field of law as such, as of its own right, but public interest law as describing a particular kind of subject matter with which we deal with in our legal practice, in the legal profession. But beyond this, public interest goes another step further if we understand it in the sense of public policy. Now, you may be familiar with, particularly if you are from a civil law background, with the French term, the ordre public, or if you are from a common law background, public policy doctrine, which basically describes a body of principles which underlie our legal order. It usually comprises the social, moral, and economic values that underlie a society, that constitutes the common consensus of what is right, what is wrong within a given society. And this term of the ordre public, or as understood in the sense of public policy doctrine, basically also constitutes a general legality requirement. So in order for something to be, for example, enforceable, or for a contract to be valid, in most legal systems, there are provisions that require it to be in conformity with the ordre public, in conformity with public policy. Now, why is this relevant when we're talking about arbitration and mediation? When we look at the areas of public interest law, and I've just drawn up here a random list of different areas of the law that one might usually find as being practiced under the moniker of public interest law. I've drawn this up from Harvard Law School's website on public interest law. You will find a whole range of different topics that might be understood as public interest law, that might be understood as someone practicing in those subject matters as practicing public interest law. But I want to focus a little bit on two specific areas that are listed here. And those areas are particularly environmental law and human rights law. And why am I interested in these two specific subject areas of public interest? I'm interested in them because they particularly impact, or will impact, as is my prediction, in the next couple of years, the field of alternative dispute resolution, of arbitration, of mediation as we know it. And I'd like to talk a little bit about why that is the case. Now, those of you that are interested in public interest law, those of you that are interested in environmental law or in human rights law will, of course, be familiar with this image. The United Nations Sustainable Development Goals. Now, United Nations Sustainable Development Goals comprise a broad range of different goals that are set out to be achieved in order to comply with this overarching goal of sustainable development, of which environmental law, the environment itself, is of course one important part, an important pillar, but which also takes into account social and economic values. Now, the Sustainable Development Goals seek to put these into relation with each other. The thing about the Sustainable Development Goals is that they are goals. So they are not binding law, they are not legal principles, they're not hard law, black letter law that would directly impose obligations. But more and more, we see that these Sustainable Development Goals are impacting how regulation is made within the nation state. And particularly, we see this in the area of the European Union, of the Council of Europe. Now, as you have heard already in the introduction, my main jurisdictions of practice are Austria and Germany, the German-speaking world mainly. Now, both of these states are, of course, member states of the European Union. And this is also a reason why I'm particularly interested in those legal orders and why the question that I'm putting before you today, the discussion of public interest and its specific role in arbitration and mediation, is something that might come naturally to me. But the European Union is also exporting these ideas, particularly through free trade agreements with third states, non-member states of the European Union. The European Union is adding non-trade related factors such as sustainable development, but also issues such as labor standards or, for example, human rights standards into those treaties, and thereby imposing specific standards and values on third states. Now, let's have a look at some of these values as they exist within the European Union. We'll start with a little bit of a broader perspective, the Council of Europe. Those of you that might not be familiar with this international organization, don't mistake it for the European Union. The Council of Europe is a larger organization, although of less integration than the European Union, but it is also the harbor of a very important human rights instrument in Europe, which is the European Convention on Human Rights. And already in its statutes, the Council of Europe features in Article 3 the idea that human rights and fundamental freedoms shall be guaranteed. If we zoom in to the member states, not just of the Council of Europe, but of the European Union, we find applicable the Treaty on the European Union, which includes in its Article 2 the commitment to the values of human dignity, to respect for human rights, which in its Article 3 goes further to include a clear commitment to sustainable development. Of course, sustainable development understood as this term was developed in the framework of the United Nations as it is expressed through the Sustainable Development Goals. And going even another step further, if we look at the Treaty on the Functioning of the European Union, and not just highlighting, but looking at this provision in toto, we see that a number of international environmental law principles are included as clear commitments as operative law in the European Union. Union policy, and I quote here, "On the environment shall aim at a high level of protection, taking into account the diversity of situations in the various regions of the Union. It shall be based on the precautionary principle and on the principle that preventive action should be taken, that environmental damage should as a priority be rectified at source, and that the polluter should pay." So we see here, particularly through the precautionary principle, a highly advanced regulatory framework for environmental standards within the European Union. Furthermore, the European Union has not just paid mere lip service by now creating what it calls the Green Deal. The Green Deal is nothing other than a commitment to a sustainable circular economy in Europe with the goal of a climate neutral Europe by 2050. And that this is not mere lip service is visible by the fact that already now we have, with the EU governance regulation, a framework towards this Green Deal. We have proposals on the table for European climate law, which covers all relevant economic sectors such as transport, energy, agriculture, construction, etc., etc. Now, with this idea of public interest in mind, this overarching concept of sustainable development, which carries with it a commitment not just to the environment, but to social and economic development, to human rights, and as we see, not just soft law, but in the framework of the Council of Europe, but even more so of the European Union, as hard letter, black letter law. Now keep that in mind as we now move to the second part of my presentation, which will move in an entirely different direction now to look at the duties of arbitrators and mediators. And in the third part of my presentation, I will then tie these two together to explain what the relevance and the impact of public interest is in arbitration and mediation. Now, what are the duties of arbitrators and mediators? You would assume that this is an easy question that can be clearly answered by stating a number of rules out of arbitral procedure, by looking at material standards that bind arbitrators and mediators in their conduct. Unfortunately, it's not that easy. Once you go through the rules, you will find that it's not as clear-cut as one might expect. For example, if we look at the ICC rules, we find in Article 11 a very clear assumption that would hopefully apply to any arbitrator, but also, of course, to any mediator, that that individual must be and remain impartial and independent of the parties involved in the arbitration. But does that tell us anything about the qualification, the skill set, the training that an arbitrator must have had in order to be qualified to conduct arbitral proceedings? Article 13 gives a little bit more guidance by including in the confirmation or appointment of arbitrators that the court shall consider the prospective arbitrator's nationality, the residence, and other relationship with the countries of which the parties or other arbitrators are nationals. But again, this of course merely goes to the fact of impartiality and independence. But it also states that what is important is the prospective arbitrator's availability and ability to conduct the arbitration in accordance with the rules. So here we have at least one reference to the competence of the arbitrator, that he or she should be able to conduct the arbitration in accordance with the rules. But it's still pretty vague or open, one might say, to the skill set that arbitrators must provide. If we go further and look, for example, at the ICC mediation rules, we find here in Article 5, paragraph 4, that the center shall take into consideration a mediator's attributes, including, but this is not an exclusive list, not limited to nationality, language skills, training, qualifications and experience, and again, as in the ICC rules on arbitration, the availability and ability to conduct the mediation in accordance with the rules. Now, again, this gives a little bit more, perhaps, flesh to the provisions that we find in the ICC rules, in that one of the factors is qualification. Another factor is experience. And another factor is the training that the arbitrator, the mediator, may have additionally received. But still, it doesn't go into any substance. Let's try and exploring a little bit further if there are any other such parameters we can find in arbitration or mediation rules. Now, if we look at the Vienna rules that I am particularly familiar with, we find that it lies with the parties that they may agree upon a particular additional qualification requirement. And analogous to the ICC rules, we also find that there is the necessity that he or she be able to carry out the mandate. Similarly, in mediation proceedings, if we look at the VIAC, the Vienna International Arbitral Center Rules of Investment Mediation, we find here again, alongside the usual requirements of impartiality and independence, qualification requirement, and perhaps more clear commitment to the rules themselves that he or she must submit to the Vienna investment mediation rules. Some guidance may be found, although this is not necessarily a provision that goes to the question of the specific appointment of an arbitrator under any rules, but from the ethical standpoint, the arbitrator, him or herself, shall only accept an appointment if he or she is fully satisfied that they may be competent to determine the issues in dispute. So a kind of self-reflection that he or she will be able to conduct the proceedings sufficiently. A final rule set that I would like to present are the CARB International Arbitration Practice Guidelines on Party-Appointed and Tribunal-Appointed Experts. Now, of course, this is not a provision that goes to the arbitral or mediator expertise, but with regard to experts, there is a clear commitment to expertise in the subject matter lex arbitri or the substantive law of the contract. So there is the requirement of familiarity when an arbitrator applies his or her own expertise, that they be familiar with what they're talking about. Something that may appear natural, but obviously also in relation to the party autonomy of appointing an arbitrator or mediator, not something that is necessarily self-explanatory. Now, what kind of duties can we deduct from the provisions that I have just discussed with you? The substantive obligations for arbitrators, but I might easily also add mediators, is impartiality and independence. It's the ability. Of course, here we have the question of whether ability means competence or simply mere diligence in the conducting of arbitral or mediation proceedings. But something that is oftentimes and controversially discussed as an additional obligation for the arbitrator, but obviously also for mediators, is there a duty to render an enforceable award, or in the case of mediation, an enforceable mediated settlement? The rule that is usually cited in this regard when it comes to enforceable awards is Article 42 of the ICC rules, which finds that the arbitrator shall make every effort to make sure that the award is enforceable at law. Now, what constitutes an enforceable award or settlement? And with this question, we move closer to the subject matter of my talk today, of the role of public interest in arbitration and mediation. Now, if we look at some of the main provisions that are relevant when it comes to enforcing awards or enforcing settlements, we may of course look to the New York Convention, which in its Article 5, paragraph 2 states 2 reasons why recognition and enforcement of an arbitral award may be refused. And it may be refused if the competent authority in the country where recognition and enforcement is sought finds that either the subject matter of the difference is not capable of settlement by arbitration under the law of that country, or the recognition or enforcement of the award would be contrary to the public policy of that country. We recognize that now, don't we? The ordre public is the question by which it hangs whether an award may be recognized and enforced or not. The same is true for mediation. The Singapore Convention has, analogously to the New York Convention, the same kind of provision. Relief sought under a mediated settlement may be refused if it is contrary to the public policy, or if the dispute itself was never capable of settlement by mediation under the law of that party. Going a step further, moving into again the law of the European Union, we find in the Brussels Directive that recognition of judgments generally may be refused if it is contrary to public policy, and here it's clearly named the ordre public of the member state addressed. Now, this brings me now to the final part of my presentation, and this is what I call the Renaissance arbitrator. Now, what do I mean by this term? Of course, it sounds catchy, but what does the term Renaissance arbitrator entail? A Renaissance man, of course, might also be a Renaissance female, but the term Renaissance man, as you will find it in any dictionary, describes a polymath, a person that is capable of handling or being an expert in multiple subject matters, a person that is capable to harness different fields, bring them together, bring them into combination with each other. If I had asked you, what would you say are the prime qualifications that you seek in an arbitrator or mediator? What would you have answered to that question? Now, I can tell you that an answer that if you work in private practice, if you're discussing the selection of arbitrators, if you're a party thinking about who might be most qualified to serve as arbitrator and mediator, the main reasons that come into consideration are still experience, reputation, and expected character traits as primary in selecting an arbitrator. One of the most memorable quotes that stuck with me in Yves Desolés and Brian Garth's famous book on arbitration and the large arbitral proceedings of the 20th century, Dealing in Virtue, this timeless classic, which consists of a large body of legal sociology, interviews conducted with individuals involved in these very large arbitrations of the 1960s and 70s and onwards. One of the interviewees gave us a response to who would be the ideal arbitral secretary, a man who, when he walks into a restaurant, is automatically given the best table. Now, this is, of course, an entertaining and catchy quote. Unfortunately, it still reflects much of what is in the minds of those selecting arbitrators and individuals. And my proposal in this presentation today is whether we should not put that into question. And this is where the Renaissance arbitrator comes in. The Renaissance arbitrator is someone who looks beyond those factual or legal questions immediately related to the dispute. Now, if we look at the current situation of what is required as a qualification that arbitrators must bring to the table, of the duties in rendering an arbitral award or in reaching a mediated settlement, is if we say that there is a duty to render these enforceable, the award must comply with the ordre public, with public policy of the state, where most probably this will be enforced. Now, there are additional overarching or regional considerations, and any of you who have ever been involved in contractual arbitration in the European Union will be familiar with issues such as union autonomy, competition law, or subsidies questions that you also need to take into consideration and on which you will have to draw expertise to determine whether the award will be enforceable in the European Union or whether it might be perhaps contrary to EU law. And of course, there are general antitrust or anti-dumping considerations, which of course will not want to have your clients step into as a result of even a successful arbitration or favorable mediation. But will it stay with this? As societies change, as the values, social, economic, moral of our societies change, in this dynamic, this influences the law and particularly the concept of what we understand as the ordre public. And I hope that I've shown through some of the sources, the underlying principles, particularly in the Council of Europe or the European Union, that it has become clear what I mean by this. The requirements de lege ferenda that will be necessary to render enforceable awards that comply with the ordre public, particularly in Europe, but also beyond, as these ideas become exported and become necessities, economic necessities in conducting business affairs with entities that have their seats that fall within union law, are human rights, be they through binding international or regional conventions, be they through domestic fundamental rights, or may they even be from best practice guidelines and recommendations. Those of you familiar with the debates on the reform of international investment law will be familiar with the right to regulate, which comprises a state's right to regulate issues of environmental law, of public health, of safety, of increasing compliance requirements with ESG, environmental, social, and governance criteria, or sustainability requirements, or compliance with domestic or international supply chain legislation. And additionally, there are still multiple soft law instruments such as corporate social responsibility guidelines or codes of business ethics adopted by entities and which may be, again, contractually enforced through individual commitments. Let me, by way of closing my presentation, show you a prime example of how this could play out in practice, and to show you that this is not mere imagination or a thesis proposal, but that we already see these considerations entering the world of international arbitration. And the prime example of this is the 2019 Dutch model BIT, the bilateral investment treaty model that serves as a basis for negotiation between the Netherlands and other states. And as opposed to the rules that we have today in the world of commercial arbitration or in the world of mediation, we already find here quite clear commitments to the qualifications that are required that these individuals be, and this is of course perhaps something that will not necessarily reflect the spirit of commercial arbitration, which specifically, although it has developed differently, in spirit would entail not just lawyers serving as arbitrators, but particularly economists or other experts competent in the area of a particular dispute. But here it speaks of jurists of recognized competence. And what does that mean? And what does it require of the tribunal? It requires of the tribunal, at least collectively, to carry expertise in public international law. But this is not enough. Public international law, including environmental and human rights law, international investment law, as well as resolution of disputes arising under international agreements. 10 years ago, who would have thought that environmental and human rights law would necessarily be among the qualifications sought after in an arbitrator or in a mediator for that matter? Specifically, the Dutch model BIT includes a provision on sustainable development. It commits the parties to contributing to the objective of sustainable development. What does this entail? It entails the encouragement of high levels of environmental and labor protection, of the inappropriateness of lowering levels of protection afforded by domestic environmental or labor laws. And finally, a reaffirmation of obligations of the mutual multilateral agreements in the field of environmental protection, labor standards, and the protection of human rights to which they're party. And here it gets quite specific. It lists a number of these. It lists the Paris Agreement. It lists the fundamental ILO, International Labour Organization conventions, and it lists the Universal Declaration of Human Rights. And let me remind you here that the Universal Declaration of Human Rights as such is not necessarily a binding instrument. It's a General Assembly resolution and thereby just a recommendational document, although some scholars argue that large parts of it have in fact become customary international law or constitute an authentic interpretation of the UN Charter. But by referencing these instruments, they are attributed legal value. And which arbitrator or mediator that you have talked to in the last couple of weeks, months, or in your entire professional experience, can you think of who could list you the 8 fundamental conventions of the International Labour Organization, let alone whether they are familiar with such an instrument? But once we have arbitral legal frameworks, or in the case of mediation also, which reference these documents, you will have to assume that an arbitrator or mediator is also familiar with these instruments, has been trained in, brings qualification in these areas, no longer just of private law, but of public law, and more specifically, public interest law, in that which underlies public policy, which underlies the ordre public. The Dutch model bit also addresses corporate social responsibility. It states that investors and their investment shall comply with domestic laws and regulations of the host state, including laws and regulations on human rights, environmental protection, and labor laws. That the contracting parties reaffirm the importance of investors conducting a due diligence process to identify, to prevent, to mitigate, and account for the environmental and social risks and impacts of its investment. And you see already, again, how can you determine this if you are not familiar with not just international, not just European law, but also domestic fundamental rights? A core competence of public lawyers that suddenly becomes interesting in your profile as arbitrator or mediator. And finally, if we look at the provisions of the Dutch model BIT on expropriation. Now, any of you who have studied the law of expropriation, be it under domestic law or be it under international law, will be familiar that expropriation is generally considered something that is a valid sovereign instrument. States may expropriate, albeit under the circumstance that it's in the public interest and that there is appropriate compensation. However, there is this phenomenon where title is not withdrawn, but still the value of property, of investment is decreased. And this is a phenomenon which is termed indirect expropriation. Now, this is a controversial field in investment law, and particularly also under domestic expropriation law. But if we look at the Dutch model BIT, it tells us a set of circumstances which specifically do not constitute indirect expropriations, namely any form of legislation, albeit that is not discriminatory, that is designed and applied in good faith to protect legitimate public interests, such as the protection of public health, safety, environmental public morals, social or consumer protection or promotion, and protection of cultural diversity. Now, who will determine whether something is a legitimate public interest? Who is merely trained in contracts and procedure? Who is an expert in long-term gas transportation contracts, in construction disputes? We find suddenly a necessity of arbitrators and mediators to consider the public interest in rendering awards if in the future they shall still comply with the ordre public, which means nothing else than that an award or that a mediated settlement be enforceable. With that, I conclude my presentation and look forward to the next 20 minutes of questions and answers. I'll be happy to engage with you if you have any. Looking forward. Thank you for your attention.
Thank you so much for that informative presentation, Markus. We've had some really nice feedback from our students already. Someone said that it was a really beautiful, informative session. Another student has said that these concepts are really interesting. We haven't had a talk quite like this before. I'm sorry about the confusion at the start. ICC, I saw that. I thought International Criminal Court. Suppose what you said, International Chamber of Commerce, makes a bit more sense. Maybe one day, who knows? We do have a few questions already from our lovely audience. Anshu has asked a very broad question, which is, how, in your view, does public policy impact mediation and arbitration?
Thank you. Thank you for this clarification question, as I would see it. The factor of public policy is one that can be viewed from two perspectives, as I've described it in the introduction to my presentation. First, it may be understood as broader range of interests of the public, of civil society. And if we view it as that, then of course we enter the broad policy discussion of whether we find that alternative dispute resolution, whether arbitration, whether mediation is in fact something that we find is desirable in our legal system, whether it is something that we wish to have as a tool set in dispute resolution, or whether we follow the criticism of shadow courts, of intransparency, of double hatting, of other criticisms that we find particularly also in the debate on international investment arbitration and mediation for that matter. But when we view public policy as a legal concept, as something that may be a bar to enforcing an award or enforcing a mediated settlement, then the role, in my view, is quite obvious. public policy is something that you need to take in mind as you render your award, as you formulate the mediated settlement. Without this consideration in mind, and with all it entails, and as I've tried to demonstrate, this is quite broad today, and it will continue to broaden, and it will be continuing in the direction that the European Union is going today. You see the discussions we have in society on climate change, the climate crisis, on the necessity of following human rights along supply chains. This will become more and more regulated. And as it becomes more and more regulated, it will also be clear that it expresses certain values. And these values then will also become part of the ordre public. And if you want to render something enforceable, you will have to consider it. I hope this answers the question. Sorry, you are still muted.
Sorry about that. Thank you for that thoughtful answer. The same student has also asked, would you be able to please explain a little bit about the Circular Economy Action Plan that the EU Commission adopted last year?
Of course, thank you. First, not trying to avoid answering the question, but the European Union has really tried in this regard to also form a transparent communication strategy, and thereby has some very informative presentations on its website. You will find it on the website of the European Parliament, but also of the European Commission. So I encourage any of you who are interested in these concepts to look it up following the presentation. But when we talk about circular economy, what we mean is an economy that moves away from use and consumption, meaning that something decreases through our use to something that will be reused, that will be recycled, that we take a life cycle view of products, that we encourage reuse, that we encourage recyclability of products, but also, of course, having these considerations seep into the services industry and others. Now, what the European Union has presented through a number of initiatives, the larger proclamation being the so-called European Green Deal. Of course, the term Green Deal is not by coincidence reference to Franklin D. Roosevelt's New Deal of the 1930s, which was meant to combat the global economic crisis. Because what the Green Deal seeks as a measure, of course, towards protecting the environment is to restructure the entire economy of Europe. And it does so by a number of measures. There are a number of regulations, directives in the pipeline. And the most recent proposal by the European Union has been the Fit for 55 program, with a number of different measures aimed at achieving such a circular economy. So if you want to continue looking into those ideas, look up the Green Deal, look up Fit for 55, and have a look at some of these proposals.
Thank you, Markus. We do have some more general questions to do with arbitration. A lot of our students are just starting to learn about arbitration, so it's quite a new concept for them. Someone has asked, what happens if a party defaults after an order made by the arbitrator?
Could you perhaps clarify what you mean by default, in what sense?
Well, I suppose if they've made an agreement, if the arbitrators come to a decision, what happens if a party disobeys that and breaks the terms of that agreement?
So unfortunately, I can only give you a very lawyerly answer that it depends. And as in any question of arbitration or mediation, the first thing you will have to look at is the specific rule set, which will provide guidance on how to further proceed if a party disobeys an order made within an arbitration. if there can be no mutually agreed solution in that case. But unfortunately, I can't give you, it would be very, very professional to give here a boilerplate answer, because it simply depends on the rule set that you apply.
Of course, we hear that answer a lot in law. It depends. It's a very common answer. Thank you. Someone else has asked about how legal costs and arbitrator's fees are dealt with in arbitration. Would you say that that varies as well, depending on the service?
Again, it depends. Obviously, it will well, the clear-cut answer is that set out in the various set of rules, or can, in an ad hoc agreement, be directly agreed with the arbitrators. Depends, right? It's usually a fee that depends on the scale of the dispute, and not on the services rendered by the arbitrator.
Of course, thank you. We have some questions about human rights law, just very general questions. Someone has asked, in your opinion, how can human rights issues come into play in police matters? Would you be able to give your perspective on that?
So again, this is a very broad question, so I find it difficult to answer to that. Human rights is obviously a consideration that basically underlies, from the spirit of what human rights are and what they aim to protect, any form of conduct. And of course, we see it very often understood as a set of values which underlies processes of peaceful, and perhaps I'll take it a little bit in this direction, peaceful settlement of disputes. And one of the core, of course, values that we find in human rights is that basically we have a certain limitation on what states can do vis-a-vis the individual. And this, of course, comprises a wide range of considerations that really would be difficult to go into on the basis of such a broad and general question. But if I can take again the turn from the peaceful settlement of disputes to one of its main branches, arbitration, and so from a domestic perspective.
Thank you so much for answering our questions. I think that's all the questions that we actually have for now. But thank you so much for attending today, Markus, and giving up your time to do this. If we do get any more questions, would it be okay for me to forward them to you later?
Of course, please do so. You find my contact details on the slides, and obviously also you find my contact details on the University of Passau's website. So if you do have any questions that haven't been able to answer, if I haven't answered fully any of your questions, please just shoot me a quick email and I'll be happy to respond. So thank you also for the invitation and the opportunity to speak today.
Thank you very much. It's been really informative. It's quite a niche area. It's been interesting for a lot of our students. I think it's quite a new area for most of them.
Well, I've tried to show in the future an area to become active, to look into, and I can assure you that it will not stay very much niche for long.
Of course. Thank you so much. So just before we go, I'd like to remind everyone to please fill out the feedback form. It has been shared in the chat now in order to receive your e-certificates. And if you are interested in learning more about arbitration and mediation, Mediate Guru does provide certificate courses from qualified legal professionals. They can be accessed at www.mediateguru.com. More information has been made available in the chat. And finally, if you don't want to miss any updates from Mediate Guru, feel free to follow us on our social media handles. We are at Mediate Guru on Instagram and YouTube, and at Guru Mediate on Twitter. Thank you so much, everyone, for joining. Stay safe, stay healthy, and we hope to see you all again soon. Thank you again, Markus.